May it please the court, Your Honour, my name is Kennedy, initial AS, and I appear on behalf of the defendant, Miss L. Stone. Miss Stone is currently 46 years of age, and she was 45 at the time of the offence. She has had no prior convictions of any kind, and while on bail for this offence, has been fully compliant with all conditions and has suffered no breaches. Miss Stone is currently receiving a government disability pension and is unable to work due to her deteriorating blindness. It is, however, accepted by Miss Stone that this offence is serious, as reflected by its maximum penalty of life imprisonment. I would first like to direct Your Honour to provisions subject to a plea of guilty. Pursuant to Section 13 of the Penalties and Sentences Act 1992, hereafter referred to as the PSA, Your Honour must take Miss Stone's plea of guilty into account. In my submission, both the plea itself and the early timing of Miss Stone's plea is a significant mitigating factor. Miss Stone indicated a plea of guilty at the earliest opportunity, informing police that she was willing to plead guilty prior to the presentation of the indictment. The plea was then entered into after arraignment. As noted in Thompson and the Queen, pleas of guilty entered into at the earliest point of time should be analysed on its value and may adopt a discount for sentencing. Also, as per Signato and the Queen, a plea of guilty is to be taken into account in mitigation as it shows remorse from the offender. Here, both her early indication of her intention to plead guilty and her plea of guilty proves a degree of remorse. Section 13, capital A of the PSA further requires that the court take into account any cooperation with law enforcement and reduce the sentence as imposed. Miss Stone surrendered herself to police the following day and made full and frank admissions in regard to the offending. It must also be considered that the community has been spared the cost of a contested trial, and it also ensured that the victim will not have to relive his experiences. Your Honour, if I may now direct you to the case of Oakes and the Queen, in which His Honour ruled that a woman's actions and her level of culpability in relation to them should be assessed during sentencing. Your Honour, may I now direct you to the case of Oakes and the Queen, in which His Honour ruled that a woman's actions and her level of culpability in relation to them should be assessed during sentencing. Miss Stone has described a feeling of her emotions building up as a result of the abuse she suffered from the complainant. Miss Stone has no history of violence prior to this offence, and this is the first time she's been involved in a relationship where violence has been a feature. Her exposure to physical violence from the complainant has led to her developing a tendency to physically retaliate against violence. During the course of her relationship with the complainant, she's been subject to at least 3 years of frequent emotional and physical abuse from him. As a result of this, the court-ordered psychologist is of the opinion that she has reduced capacity to make sound judgments, and it makes her more likely to resort to physical retribution to those who do her ill. However, I do submit that my client poses no immediate threat to the community, and only as a result of her ill treatment and ongoing abuse did she commit this offence. Your Honour, may I now direct you to the 2011 decision of Yarwood, where it was held that mental incapacity not amounting to insanity may reduce the moral culpability of an offence. While a formal diagnosis was not provided in the pre-sentence report, the court-ordered psychologist did state that Miss Stone has a reduced capacity to make sound moral judgments. As per the Queen and HBI, considerations of general deterrence for sentencing should be dependent on the mental illness of the offender and its effect on the mental capacity at the time of the offence. Miss Stone has limited capacity to make sound decisions, and this has aggravated her actions during the offence. It is submitted that while Miss Stone was not provided with a formal diagnosis, the court should still consider her history of abuse and mental incapacity as a mitigating circumstance for this offence. Your Honour, I would now like to direct you to Section 161, capital B, subsection 3 of the PSA, in which the court has a discretion to declare the respondent to have been convicted of a serious violent offence. In Everly and the Queen, His Honour considered that the declaration of a serious violent offence must only be subject to offences of a particular nature where circumstances take it beyond the norm of that offence. As per the Queen and McDougall and Collis, where these factors are not considered, it is likely to result in a manifestly excessive sentence. However, the element of premeditation was considered in the case of the Queen and Oakes, as it may lead to a serious violent offender declaration. However, it is also submitted that there is no element of premeditation in this offence as a result of the emotional and psychological sufferings of Miss Stone. Your Honour, I do submit that Miss Stone's offending was not adequately outside the norm of a malicious intent offence, as she evidently cooperated with police for these proceedings, and through her early plea of guilty has indicated remorse for this offence. I would now like to direct Your Honour to the case of the Queen and McDougall and Cullis, where the declaration must also warrant the offender serving at least 80% of their sentence before eligibility of parole. There is no doubt that Section 161 capital A and capital B of the PSA were written to protect the community from offenders who pose risk to their safety. However, Ms. Stone has no history of violence prior to this offence and has suffered long-term abuse from the complainant. Section 1 and subsection 2 of the PSA outline the provisions to determine circumstances that warrant a serious violent offender declaration. As previously submitted, there is no belief that Ms. Stone will re-offend and pose a threat to the community. Her offending in this case was focused solely on the victim who had abused her for over a number of years. Furthermore, Your Honour, Ms. Stone has a good prospect of rehabilitation and should not be subject to a serious violent offender declaration. Therefore, we submit that the court should use discretion when imposing a head sentence to this degree. Your Honour, I would like to tender a number of character references from community groups whom Ms. Stone volunteers for. Ms. Stone can be described as having a kind and caring nature, and she is also an active member of the community. These references were provided with a full awareness of my client's offence. However, this was described as out of character for Ms. Stone. Your Honour, although a term of actual custody is within range for this offence, I submit that my client should instead receive a suspended sentence. While Your Honour may believe that general deterrence would be suited as a term of actual imprisonment, we find it appropriate that Ms. Stone's limited capacity and history of trauma mitigates the need for such justice. Your Honour should also consider Ms. Stone's good character as a community and her long-term disability upon sentencing. Ms. Stone's sole income in the form of a disability pension will be suspended if she has to serve actual custody. And as my client has no dependents to transfer these pensions, she will lose her rental agreement and have no place to live upon release from custody. In Latham, it was held that a suspended sentence may be appropriate where considerations justifying or encouragement of rehabilitations are strong. If Your Honour is, however, unsatisfied with that submission for a wholly suspended sentence, I instead submit that Your Honour imposes a term of parole. We once again ask for discretion to be granted in regard to serious violent offender declaration to ensure that Ms. Stone is not required to complete 80% of her head sentence. The court should also give weight to submissions made in regard to Ms. Stone's character, her mental incapacity, and also her physical disabilities. As per Ryan and the Queen, the good character or conduct of an offender may reveal redeeming features relevant to sentencing, and these will not be disregarded as immaterial. As per section 160 capital B of the PSA, if a sentence of 3 years of lower is provided, the court must fix a parole date. However, as in section 174 of the PSA, if Your Honour imposes a head sentence of more than 3 years, we submit that Ms. Stone should be eligible for release after serving 1/3 of her sentence, and a suspended sentence then be enacted. As in Souter and the Queen, given Ms. Stone's plea of guilty and her multiple mitigating circumstances, her time served should be reduced. Unless there is anything further, Your Honour, that concludes my submissions in respect to this sentence.